Go ahead, Sarah.
Here's my question. Has the Coleman campaign and or legal team weighed in with a legal opinion of any sort on what the governor has to do and doesn't have to do, depending on these proceedings?
No.
Okay.
All right. Thanks, Sarah. Any other questions? If you have a question, please press #8 at this time. Last call for questions. All right, our next question comes from Kevin Dukeshire from the Minneapolis Star-Tribune. Go ahead, Kevin.
Okay. They were talking to me there. Ben, I just want to be sure I understand. Again, you say your preferred remedy certainly is to allow these votes back in rather than going back and taking some out. Are we still talking about the 4,400 some wrongly rejected absentee ballots or absentee ballots that were rejected that you believe were wrongly rejected? Are those the numbers that you're still talking about here?
Yeah, well, yes. I mean, the court is free to look at a larger universe than that.
Right.
We believe that we also talk about how the 413 that were part of the canvassing board count but were objected to by one party or another, and at least some of those, the majority of those, remain uncounted. They should be brought in. If you'll remember, Mr. Gelb ballots that he believed should have been counted, not all of those have been counted. We asked for those to be included as well.
So, Ben, are you able to put a number then on, sort of a general number as to how many ballots you're hoping that the court, in fact, will recognize and count?
Well, I mean, we're not going to put a precise number on it because I don't know what the precise number is. But the 4,400 that we identified in our summary judgment motion.
At least the 4,400.
At least the 4,400.
If not more.
The remaining of the 413.
Right.
That have not been counted.
Right.
Plus the Geldman list.
Okay.
At a minimum is what we would suggest should be looked at by the court or should be looked at to be included.
Mm-hmm. Okay.
All right. Thanks, Kevin. Our next question comes from KSTP.
Hey, Ben, it's Tom Hauser. I was wondering, as you approach now the Minnesota Supreme Court, how do you expect them to rule differently on some of these same arguments you've been trying to make in other forums? Just explain to me the difference in the nature of how the Supreme Court might look at your arguments compared to what the election contest court was looking at or the canvassing board was looking at.
Well, the canvassing board, I think, believed that jurisdictionally it did not have the power to look at really any of these issues that we're raising. They believed and made pretty clear that authority rested with the contest court. When we got to the contest court, these judges took a much more restrictive reading of what they believed their authority was. And so they didn't want to look at equal protection arguments. They didn't want to contemplate that they had actually created illegal votes in the count by their strict compliance standard. The Supreme Court, as the highest court in the state, has the obvious authority and has done so in the past to say, well, of course, we can look at all this, and in fact, we can order a contest court to look at those things. We can tell a contest court that they have the authority to do it. So the Supreme Court is the ultimate word in Minnesota on what the scope of what can be looked at is. Therefore, it is really a fresh look that the Supreme Court takes at these issues under the way Minnesota law works.
Okay, thank you.
Great. Our next question comes from Brian Bax from the Associated Press.
Sorry, the host has opted to drop you from the call. Thanks for calling. Goodbye.
Folks, we don't know why we were cut off there, but we're dialing back in.
Good afternoon.
Welcome to the court.
Thanks. I'm connecting you now. Oh, by the way, you're muted on this call. I also need to let you know the call is being recorded.
Could you clarify? It's not 1,359 on top of 4,800. Isn't 4,800 the maximum that you're hoping to get in?
Well,
Sorry, the host has opted to drop you from the call. Thanks for calling. Goodbye.
Okay, we've been dropped twice. We're going to try one more time.
Good afternoon.
Welcome to the court.
Thanks. I'm connecting you now. Oh, by the way, you're muted on this call. I also need to let you know the call is being recorded.
no, I'm talking hypothetically. It's not in the brief. I'm talking hypothetically with you. The question was that I was responding to was what was the scope of the authority of the Supreme Court.
All right. I think our next question, I'm not sure who it's come from. If you can just identify yourself and ask your question. Go ahead. Go ahead.
Hi. Today, Americans United for Change and two other independent groups announced that they're going to be airing a TV ad calling on Governor Pawlenty to do his legal duty and certify should Franken win in the Supreme Court appeal.
Sorry, the host has opted to drop you from the call. Thanks for calling. Goodbye.
Detect a pattern here, don't we?
Good afternoon.
Welcome to the court.
Thanks. I'm connecting you now. Oh, by the way, you're muted on this call. I also need to let you know the call is being
That
recorded.
it's going to be a 5-figure cable ad buy.
A 5-figure cable ad buy. Okay, good. I mean, look, the notion that anybody is seriously going to take any advice from any of these groups is, I think, misplaced.
All right, thanks. Our next question, last one, comes from Rachel Stassenberger, once again from the St. Paul Pioneer Press.
First shall be last, and the last shall be first.
Thanks, Ben. I think it would help me clear up the confusion on what number of ballots you are asking to be counted to have you confirm that, in fact, you're not asking the Supreme Court to count any ballots. You're asking the court to send it back to the lower court, and they can figure out, based on the rules of the Supreme Court, decide.
Sorry, the host has opted to drop you from the call. Thanks for calling. Goodbye. Good afternoon.
Welcome to the...
Thanks. I'm connecting you now. Oh, by the way, you're muted on this call. I also need to let you know the call is being recorded.
Imagine for me that you win on this appeal, and it does get sent back to the...
Sorry, the host has opted to drop you from the call. Thanks for calling. Goodbye. Good afternoon.
Welcome to the court.
Thanks. I'm connecting you now. Oh, by the way, you're muted on this call. I also need to let you know the call is being recorded.
All right, that's all the time we have for today. If anyone has any follow-up questions, feel free to shoot me an email at terrickson@colemanforsenate.com. Thanks and have a great day.
Sorry, the host has opted to drop you from the call. Thanks for calling. Goodbye.
Okay, folks, we are apparently persona non grata, or at least there's somebody with who's pushing buttons who just accidentally keeps cutting us off. I have no idea why that would be. This has been a live report, or if you're hearing it back on tape, wondering how many times the uptake was dropped from the conference call, we'll have to go back and count. But this is what has happened so far. We have had Ben Ginsberg announce that he has filed his paperwork with the Minnesota Supreme Court, and he was explaining, for the most part, what it meant. We'll have to go back and kind of assemble that and get out the story to you. This is the UpTake. We will now go back to, I believe, live to the Senate. We'll see here.